Hi, I'm Phillip Cha. I'm a mediator and founder of Cha Mediation Services. I specialize in mediating employment and business disputes. In this segment, I want to talk about mediating a wage and hour class action lawsuit. This topic was inspired by the recent U.S. Supreme Court oral argument in the Epic Systems versus Lewis case. Now, this case had to do with the enforceability of class action waivers in employment arbitration agreements. And the case is a big deal because if these types of waivers are upheld, then employers can prohibit employees from filing class action lawsuits. If you want to read more about this topic, I'll leave a full case site and a link to the argument transcript in the description box below. In terms of mediating a class action case, as opposed to a single plaintiff case, the recipe for success at a mediation is the same for both. That said, there are some things that are unique to class actions, which we'll talk about. The first issue in mediating any case is the right timing for mediation. The parties typically have control over when they go mediate the case. For example, parties can decide to mediate pre-litigation, before any lawsuit's actually been filed. They can mediate early in the litigation, when they haven't spent significant time and money. They can also mediate well into the case. And mediating at each of these different phases has its pros and cons. If you want to know more about the right timing for mediation, I did a prior video on this and I'll leave a link to that in the box below. A pre-litigation mediation makes sense when the parties want to control their costs and avoid the negative publicity of a lawsuit. However, the downside is that the parties typically have very little information to go on in terms of evaluating their case. This creates uncertainty, and uncertainty can be counterproductive for settlement negotiations. If you can accept some level of uncertainty in the interest of an early resolution, a pre-litigation mediation may still make sense, especially in a single plaintiff case. However, in a class action case, uncertainty I think is a bigger risk, and that's because evaluating a class action really comes down to analyzing the class data. And by that I mean things like knowing the number of class members, the effective pay rates, the number of work weeks during the claim period, and so on. Now, that being the case, if the parties still want to mediate a class action prior to litigation, I think it's critical that they agree to an informal exchange of the class data in advance, even if it's just a small sample. Once the parties have the data, it's equally critical that they spend the time and the resources to thoroughly analyzing that data. As a mediator, I often preach that the key to success at a mediation is to come in prepared. If you want to hear more tips on how to prepare for a mediation, I'll leave a link to one of my prior videos in the description box. In terms of analyzing the data, attorneys can use their internal firm resources, like various computer software programs and paralegals. Attorneys can also farm out the analysis to an outside contractor or vendor. Either way, knowing that data will put you at a clear advantage at the mediation, so the investment will pay off. Another issue to consider on the timing for the mediation is whether there are dispositive motions pending. In a single plaintiff case, that's usually a motion for summary judgment or a motion to dismiss. In a class action, the motion for class certification will make or break the case. So it makes sense for the parties to think about whether they should mediate before they invest the time and the resources on the motion for class certification, or maybe even right before the ruling on the motion when both sides have some uncertainty and risk. Waiting until after the ruling on the motion is a bigger gamble, and it could increase the value of the case significantly if the class is certified. Going back to the Epic Systems case, the same timing considerations are in play for cases where you have employment arbitration agreements with class action waivers. There may be benefits to mediating before the court rules on this issue. And on the flip side, waiting for the court to rule is a gamble that may or may not pay off. Lastly, counsel need to understand that settlements in class action cases are much more complicated than your settlements in a typical single plaintiff case. The main difference is that the court actually has to approve a class action settlement on the grounds that it's reasonable and also in the best interests of the class members. With this in mind, counsel need to come in prepared and ready to negotiate all of the moving parts of a class action settlement. For example, the party should come in ready with a quote from a vendor for settlement administration fees. Parties also need to be up to speed on the most recent legal developments for issues like how much the court will approve for attorney's fees, as well as whether reversions are allowed for unclaimed settlement payments. The law on these issues is constantly evolving, so you can't assume that what worked on a deal a year ago is going to work today. Thank you for tuning in. If you liked this video, please hit like and subscribe to my YouTube channel. You can also check out my website at www.chamediation.com. I'm also on social media. Links to my Facebook, Twitter, and LinkedIn accounts is in the description box below. And in the meantime, stay tuned for my next video. I'll see you soon.